Hello, everybody. Good afternoon, or I guess good morning, depending on where you happen to be sitting right now. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I want to welcome you to today's webinar on the 10 things you should be doing to get ready for the rule. Regulation F, the debt collection rule, however you want to describe it. It may seem like you have all the time in the world to start working on how you're going to comply with Regulation F, but the clock is ticking, and some of the changes that you may need to make could take months. Companies need to start prioritizing what will they need to do to start addressing first, and which changes are going to be the most important. To help companies identify those priorities, we've assembled a panel of experts from across the ARM industry in this webinar, which is being sponsored by TCN, to share the steps they think need to be taken in the order that you need to take them. I did want to take a quick second and talk about accountsrecovery.net. Specifically, I wanted to mention a video series called You Wanted a Rule, You Got a Rule. Obviously, there's a lot to go through when analyzing Regulation F, but this series features John Bedard from Bedard Law Group going section by section through the rule and breaking down what each section means for the ARM industry. I think we're 15 or 16 episodes in right now, and John's already provided a ton of great insights. New episodes are being published every Tuesday, and all episodes are available for free in the video section on accountsrecovery.net. If you're online right now and you've got the chat box open, I just put a link in there where you can check out all the videos. Now, let me tell you a little bit about today's speakers. Sarah DeMoss is the Director of Compliance and Licensing at Premier Credit of North America. She also acts as in-house counsel for the organization. Besides general compliance matters like complaints, quality assurance, and auditing, Sarah also oversees training, HR, and legal for the company. She's been at Premier for more than 6 years. Prior to joining the company, she worked at the national collection law firm of Rausch Sturm and is licensed to practice law in both Indiana and Minnesota. Ari Durman serves as general counsel and chief legal officer for Harris & Harris. Ari is the company's key legal strategist on all major business transactions and complex compliance matters. As part of his role, he advises executive management on regulatory issues within the industry, drafts and negotiates client and vendor contracts, spearheads all legal defense efforts for the company, and oversees the selection and management of all outside counsel. Furthermore, under his direction and supervision, Harris's legal compliance department researches new collection legislation and case law, handles corporate licensing and insurance matters, and facilitates training for account representatives. Catherine O'Brien is the general counsel and chief compliance officer at United Holding Group. She is an RMA International and ACA International certified compliance professional and has done frontline collection litigation and FDCPA defense work. Her focus for the past 15 years has been on compliance. Judd Peak is the chief compliance officer at Capital Accounts. He brings more than 2 decades of experience and is recognized as a leader for ARM and revenue cycle compliance, with particular emphasis in the healthcare industry. Judd has built compliance programs at 2 ARM companies and has honed particular expertise in healthcare privacy, patient payments, and industry best practices. The format for today's webinar is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them as we proceed through our conversation today. To submit a question, you can do so either via the chat box or through the Q&A tab on your Zoom webinar control panel. This event is being recorded, and a recording will be made available in the coming days on accountsrecovery.net. Finally, since we have a panel of lawyers with us today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area and should never be used to replace the advice of your own legal counsel. All right, let's start our discussion. We've got 10 things we're going to try and get through in the next 55 minutes. So let's see what we can do here. But Catherine, I'll give you the first one because it was your idea. And probably of all the 10 is probably the one that people are going to like the least.
That's right.
They have to actually read all the pages of part 1 and part 2.
Well, maybe not all the pages, but you definitely you really have to just sit down and read the actual rules, which is only like an inch. And I think it's 75 pages of the comments. The comments give just really specific examples. I hear the same questions over and over again on some of these webinars, and the comments answer a lot of them. So unfortunately, everyone just has to take the time to sit down and read them. The other 900 pages of the CFPB explaining how we got here, it's all great information, and maybe one day it might help, but I break it up into little chunks is what everyone keeps talking about. The seminar by John Bedard is great, but you really do. You have to just sit down and read the rules and the comments. Womp womp. Sorry, everyone has homework.
I will, underscore that, Catherine, because, we're all in the compliance realm and we're expected to read them and understand them and implement. But I actually printed out copies and gave it to ownership of my company. I said, please read this. And to their credit, they did. Just, the text of the rule itself, not all the commentary and everything else that goes along with that. But to me, it establishes that communication channel between the compliance officer or the general counsel or whatever the role is, and the operational leaders of the company, because a lot of this is not just knowing what the rule says, but knowing how to implement it and change a lot of your processes and practices to be compliant. And that requires, that's a team effort.
Yeah, the more people in your company that have read them might catch those little nuances of some process that you're not as familiar with. So
Right.
I totally agree. Everybody, please just read the rules. You have to.
You guys are making great points. I think it's very incumbent on, if you're a compliance officer, if you're a lawyer at your company, one of the best things you can do, the best use of your time, can be to distill the rules. I think one of the things we did at our office, our compliance team got together and we broke it down into 8 bullet points. Now that's very simplistic for analyzing the rule. Of course, there's thousands of pages to this thing, but when you break it down to 8 headers, of course, you could have a discussion on each one of those things, just like we're doing today. What 10 things can you do? When you break it into bite-sized pieces, that's a big benefit that you can provide as a compliance officer, as an attorney to your business, because that's going to spark those discussions on each of those topics. And then you're going to have to go back to your clients. And we've started doing that a little bit. I think we even have a few on a webinar today. I'm really excited about that, because this has to be a team effort. And I think if Chopra gets confirmed as a new director, he said a few weeks ago that I heard he was a little bit upset that original creditors weren't regulated in the rule. And what does that mean? That means that they're going to view the rule through a lens of how to impact the entire industry. So that's our skip tracing vendors, that's our clients, it's collection agencies, it's debt buyers. Everybody in this ecosystem is going to come under regulation, and you're going to have those conversations with each of those types of companies and entities that you come in communication with. The first step's obviously reading it, but then I think you can break it down, because to hand it to a client and say read 1,000 pages, they don't have the time to do it. So I think it's incumbent on us to take some of those steps can really benefit everybody.
Yeah, that's a good point, Ari, because from my perspective, that's value added to your client base. You're one, notifying them about this. This might not be on their radar, and some of the more sophisticated clients, they need to know, because the new debt collection rule isn't expressly applicable to creditors, but it is implicitly, because of like UDAP provisions and state laws that would consider a violation to possibly be a UDAP to the creditor. And they have, their vendor oversight obligations and everything else that goes along with that. So they do need to be cognizant of that. And just because we read it in a vacuum doesn't mean that that's the end of the understanding. I like the focus on extending that to our, upstream to our clients, as well as downstream to our business associates or employees or whoever else might be implementing policy.
Well, and also just from a practicality standpoint, when you're thinking about your implementation plan, I don't work in IT, and I say, hey, I just want you to turn this on. All you got to do is just flip a button, right? And they laugh at me and say, well, programming takes X, Y, and Z, and we have to prioritize, and we have to call the vendor, et cetera. So in order to really get a true timeline and analysis of your resources, you kind of have to involve other people early.
Absolutely. Another early number 2 on our list, something that you need to adopt early and start working on, is that DBA. That's going to be a big deal. If you have a name that has collecting, collection, debt, I think recovery too is another one that people have mentioned. I'm sure there's more to add to the list. If you're on the edge, be mindful. That's kind of an easy picking for a lawsuit. If you leave your company name and they believe it's directly tied to a collection agency, that's expressly discussed in the rules that you are going to read. But if getting a DBA on your name, it takes time, it takes paperwork, it probably takes programming. You might need to update letters, your policies, procedures. Again, all of these, like Sarah was just talking about, takes a lot of steps and a lot of time, and you got to make sure you hit all of them. So that would be my number 2, is if you do have one of those names, really start reaching out to your attorney or whomever you choose to try and figure out a workaround around that. Because that one is, I think, going to be really easy to get busted for if you don't update.
Now, Kathy, this is primarily for leaving limited content messages, or there are other purposes that a company might want to DBA to. And yeah, I think that's very applicable. Something I'd add to that is a lot of states, for your licensing, they might ask for DBAs. So you got to be cognizant of where you're licensed, and do you need to update your license file with the state administrator?
Yeah.
It's a good point as well, because we know California is we've already seen a lot of activity. I forgot the exact name of their agency, but that licensing entity that's going to be coming out and regulating all of us at the end of this year or early next, and opening up that application process. As we start to see more mini CFPBs and we start to see more licensing audits go on, I don't think this will be limited to the CFPB limited content message area only. I think it's going to make its way into a lot of these licensing authorities that have maybe overlooked what's inside of someone's name. And I think we're starting to learn that the more simple and the more vague you can be, blank and blank LTD or whatever, leaving out the words collections, recovery, like you guys are saying, is going to pay big dividends, not just for this, but also with a lot of the authorities we've come to know and love so much over the years.
Yeah. And again, this is a decision. If you don't want to use the limited content message, you do not have to. It is not required. But if you do want to use that, you're going to have to consider that name. You can still use other voicemails, and be careful.
So I guess the step before the step is deciding whether or not you're going to use the limited content message, and then decide whether or not you're going to change your name. There are a couple of questions that have come in on this particular topic, and one is, are we actually going to be able to use a DBA, as there seems to be some questions on whether a DBA can be used. Has anybody heard anything about that? Not being able to use a DBA? Are there particular states where it's not allowed?
As long as you, like we said, update your licensing and make sure you check all the boxes where required, I don't believe there is any prohibition on using a DBA.
I think the general consensus is that if you want to leave a limited content message, but you can't because your company's name, the agency name, has those prohibited words in it, this is the solution to be able to do that. If there's some sort of movement against or outlawing DBAs as some sort of misrepresentation, I'd want that to be challenged by somebody else, but I'd also be interested in what that might be rooted in.
Well, it is true though that in a given state, you may not always be able to get the DBA that you want. You take a name like ours, like Harris and Harris. There are other Harris and Harris in the world. They may not be in debt collection, but at a front level of getting a certificate of authority to operate in that state, someone may already have that name. So you may be Harris and Harris of Illinois in that jurisdiction. You may be Harris and Harris of Chicago in that jurisdiction. You may be, Harris and Harris wherever you might be. So you do want to make sure, if you're going down that path, that you do check it with, and it's usually not a collection entity. It's usually not a DFI or FID or one of these alphabet phrases, Department of Banks, Department of Financial Institutions. It's usually at the Secretary of State level in a given state when you have to secure that name. And then the next step is bringing that and working it and smoothing it into your license in that state to collect. So you do have to make sure that you don't go down a path or submit forms, which will delay the process, where name reservation is an issue. So you may have to reach out to a Secretary of State or something like that to make sure that you can determine that the DBA you want to use, if you need one, is available.
Another question that's come in, which is interesting. What if your website URL has collection in it, but it's not in your business name, or but it's on the payment site? Is that still okay to use?
I think it turns on when you use that URL in communications. So if you're leaving that URL in a limited content message, then I'd say that's problematic. But if you just happen to have that website and it's on your payment stub with your letters and you're directing consumers to go to it that way, then I don't necessarily see the need to change that. I think it does kind of bring up the issue, which is interesting. If you're leaving limited content messages with a DBA and you do want them to, well, and you do want to direct them, should you set up a mirror site for the DBA for I guess for whatever purpose you might deem
prevent
necessary?
consumer confusion, right?
Yeah,
But you
right.
can't, you
That's a
can't
good
use
one. Yeah.
you can't use a website address in the limited content message anyways. It's
Right,
not
yeah.
technically a
So it
communication.
would be for other purposes, yeah. But I'm wondering if you leave a limited content message with one name and they call in with something else, there are a lot of nuances to this that you got to be aware of and work out in actually your workflows and in your scripting that you have to be aware of. Just registering the DBA is not enough, though. You got to think about how it's going to work in practice.
This is an area though, you guys, that's going to be right for consumer attorneys that are creative. The ones that are going to sit around and say, okay, let's try on that name, let's try on that name, or okay, wait, I see it here and there. I think you're going to see some creative lawsuits come out of this very issue.
Look, as always, the key is, you definitely don't want to underthink it. You also don't want to overthink it. I wouldn't change your payment website or do something prematurely. I mean, we know dating back to the 1980s, 70s, 80s, when, when the FDCPA came out, you don't communicate on a postcard. You don't put, the name collections and a return address. I mean, we're sort of past that, right? So yeah, the same thing. You wouldn't want your URL if it says, MikeGibbCollects.com. You wouldn't want that to be on the return message like some of these companies advertise their website on return envelopes or anything. So I think some common sense probably factors into the equation as always. But when you're leaving these, very pointed, LCMs, limited content messages, you want to make sure that if you need a DBA that you have it, because that's going to really slow you down if you don't.
Okay, I'm just going to hit the pause button on our discussion briefly, and I'd like to invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay?
Hey, thanks, Mike, and to the rest of the panelists, Judd, Sarah, Catherine, and Ari. It's great that you guys have been able to share the insights so far. But again, as Mike said, my name is McKay Bird. I am a marketing director here at TCN, and many of you are already familiar, I assume, with TCN. But what we do is we provide cost-effective solutions for traditional contact centers, collection agencies, and as well as thousands of businesses around the world. TCN has continually stayed current with TCPA and the CFPB by introducing features into our platform that makes it easy. One feature is our TCN's compliance suite that has built-in natural language processing and uses smart algorithms to build compliance rules naturally. Simply just type in a rule and our compliance manager will build a rule that's easy to understand directly and digestible by anyone within your organization. Apart from traditional services that we provide in the contact center respect, we also have built into our platform data management services that help eliminate data entry errors, business intelligence and performance analytics for reporting. We have built-in call storage with speech analysis and transcription redaction, as well as IVR and payment capabilities that really help streamline the entire collection process. So regardless of size, location, application, we can provide a robust solution for your contact center that is contract free and with a transparent billing model. So I invite you all to visit us at tcn.com for more information, and we will post that site also in the chat for anyone looking for that URL. So thanks, Mike.
Thank you, McKay, and thanks again to TCN for sponsoring today's webinar. So we've gotten through two so far. Let's move on to our next one, and I'm going to sort of mess around with the list a little bit. And Ari, I wanted to bring up something that you thought was really important, and that is you mentioned it earlier about starting to talk to your creditor clients about data and getting through that process.
Yeah, I really think this is the time in which we're going to see original creditors come in and under the auspices of the rule. I mentioned before that the incoming director, who we think will be confirmed, that Chopra had said was a little disappointed, apparently, that original creditors were not wrapped into the FDCPA and wrapped into the rule. But the way I see the rule is written, and of course it may change a little bit, is there are intersection points right now where the Bureau is going to regulate original creditors through us, through the collection agency. The FDCPA is a collection agency rule. It's not an original creditor rule as written, but there's a couple intersection points that are definitely going to apply, and they're going to force the agency, they're going to force the collection agency to work downstream with its clients to basically get this aggregate compliance that the CFPB wants. And I saw a couple areas, and the panelists may see a few more, but obviously to email, and we know the best part about this rule, I know there's a lot of complications with it, but in my opinion, the best part about the rule is the Bureau expressly allows email and text. It doesn't mean it's without problem. It doesn't mean it's without complication, but they could have said no. They could have said, oh, here's all the different things that you have to do before you do it. And instead they said, well, here's a list of things, but it's not 10 pages long, it's only 3 pages long. So there is a hurdle to getting over that, but at least we have the mechanism to do it. So you take, for example, a creditor client. You want to take that email that they get from a utility client, a healthcare patient, someone else in commerce, and they want you to email them as the debt collection agency. Well, there's this debt transfer notice that has to be created, where it's got to tell the consumer they might be emailed. It's got to tell them they're going to go into collections. It's got to tell them that a third party might see this email if they have access to this address, and you've got 35 days to opt out. So we've just started taking a stab at creating that, because I think we're going to be relied upon as a collection agency to help provide that notice to our clients to stick in a billing statement. The beauty the CFPB said is it doesn't have to be a standalone notice. So where is that going to happen in the collection ecosystem? What's the language that's going to be used? Especially if you're a compliance officer, if you're a lawyer, that's a big value add that you can provide to your clients and be able to engage with consumers by email in the way they want to be communicated with. And then I think the other two really quick points are, if you're looking at a model validation letter, it's got a huge requirement that you choose an itemization date, that the balance on the letter starts from a certain date and shows all payments and credits since that date, interest, added fees, right? All those things, if you look at the model validation letter that the CFPB expects you to use, you've got to get that data point from your client. You've got to check your placement files now. And we're just starting to do that. But you've got to check those. You've got to collaborate with clients and say, hey, we need this data point if we're going to go forward and collect. That's key to do. The same thing with credit reporting. There wasn't much on credit reporting in here. Hey, don't debt park, don't do passive collection. Okay, that's fine. But if you look at the enforcement actions the CFPB has, they're really centered on getting a proper date of first delinquency, which has been undefined in our industry for years. And they said, ask your clients for it. So these are things that are on my list that I'm just starting. First step was, as Judd said, break down the rule, do everything you've got to do. But now, once you know what the rule says, start those discussions in reaching out. And that's part of the reason we sent this to a lot of our clients today to attend the webinar, because it's probably the first time they're hearing about some of this stuff. But the time is now. We've got till November. And I'm sure the other panelists have a lot more to add on that.
Yeah, I think Ari, my experience is similar to yours. And we deal almost exclusively in healthcare. And with healthcare creditors, I think it might be different than student loan processors or credit card companies or anything like that. They are very, very slow to change their data output methods and models, and how their ERH systems or their patient accounts systems are able to create and send over placement files. So if you need different data, that's going to be a long process on your client side to get them to the point where they're able to provide that. And to your point on the data delinquency, yeah, in healthcare, that's not defined. I mean, it's all over the board as far as different providers and how they define that. So you can't just have a one-stop shop or a one-size-fits-all for your clients. And it's going to be a lengthy process. I remember a few years ago when the initiative started to just start getting TCPA consent captured on the creditor side. And working with healthcare systems to do that and change their patient intake form, this is a nightmare, a mountain of work to add one line to one form. There are so many administrative hurdles in healthcare, it's hard to do. And this is going to be something similar. So think in terms of time and how long it's going to take to get that process working properly, and backtrack at that. And I think we're in the midst of it now. It needs to be started, get the ball rolling as we speak.
Okay. Let's move on to another item on our list. And Sarah, I want to bring up something you raised, and that is determine what is mandatory and what is optional.
Yeah, so we were talking about the limited content message earlier in the DBA. So that's an example of something that you can just not leave the message if you don't want to go down that trail. There's lots of different things in the rules. Some of them are optional, some of them are mandatory. It's not as easy as just looking, and some of them are highlighted and they actually say optional, but it doesn't mean it's really optional. So it's a little bit more complicated than just doing that. We're going to talk a little bit later, I think, about how state laws and other laws also intersect with this, because, hey, it may say it's optional to leave your phone number on the model notice, but in, another state, it's actually mandatory. So you kind of have to reconcile those things and decide what's truly mandatory. And when you're looking at prioritizing, you probably want to start with those things first, because otherwise you'll be out of compliance immediately. And then the other things that are kind of nice to have, or things you're still figuring out, some of the email communications and things like that, you might add that piece second.
Yeah, exactly. The model validation notice that I posted the page for, that is an optional form. You do not have to use that, but that is what the CFPB said is going to give you some safe harbor protection if you use it substantially in that, but it is an option. The limited content method we talked about, it's an option to use. You don't have to, which means you don't necessarily have to get a DBA, but that is your choice if you want to leave, safer voicemails. The validation information, that's what's required. There's a whole list of, I think, like 11 specific things that have to be in your letter. They're in the model validation notice, but those you have to have. That is not optional. But how you have them, optional.
Yeah, in my head, the two large categories of mandatory would be, that validation information, and then the prescriptions and certain behavior that you can, the call caps, not credit reporting without having given notice beforehand. Those things are the mandatory side of it. The other stuff is good for the industry, provides safe harbors, provides additional contact options. But yeah, they fall under the optional side of it, not mandatory.
And actually the call caps you talk about, those are also technically optional. They're saying you can call up to 7 times. Mm-hmm. You don't have to call 7 times. If you're only calling 3 times, you can continue that practice very safely.
Right. It's the inverse side of it. Yeah. Mandatory to not exceed, the caps. Right.
I think something we all wrestle with, though, on the defense side, right, is if something is perceived safe, by definition, it becomes an acceptable act. It becomes a best practice in the industry. And that's something I don't love about the rule, quite honestly, is there's so much focus on how to be safe under the rule that you do lose sight of, hey, that's a safe harbor provision. You don't have to do it, but we're assuming it's safe, and we're assuming it's a validated method that has a stamp of approval from the CFPB. Going outside of that doesn't per se mean you're wrong, but try telling a plaintiff's attorney that. Try telling, a fellow industry partner that you benchmark with that adopted it, or when, you're competing with another agency on a scorecard or something else, and they're using it and you're not. I mean, these are things to keep in mind, that once it's introduced into the ecosystem and it says it's a model notice, of course you can deviate. And of course you can, not use anything that's not required here. But to do so, you are putting yourself on a raft in the middle of the ocean a little bit. Might be a great navigator, but that's just something to, always keep in mind, that anytime you veer away from the safety, that nice warm blanket that the CFPB provided, it's a little bit of Wild West. And we know that in a heavily regulated industry like ours, wouldn't surprise us to see the CFPB, misunderstand their own rule or regulate by enforcement against some of these items. So just something to keep in mind.
Yeah. And I hate to say it, and I'm so sorry, but even if you use the model validation notice, it's not going to stop you from being sued. There's always going to be some plaintiffs who's still going to sue you in hopes that you settle quickly because it's new and maybe you messed up. but it's not protecting you from getting sued. It gives you the defense so that you can say, nope, I did everything right. It's basically the model. You're not going to win this suit, but it's still a lawsuit. And anytime you get sued, that's a loss, unfortunately. Sad.
All right, so we've read the rule. We've started talking to our clients about it. We've started to figure out if we need a DBA. We've figured out what's mandatory and what's optional. And now we come to maybe one of the most important components. And Sarah, that's something you brought up, and that is how much is this going to cost? Setting a budget for figuring out how much you're going to spend on complying with the rule or making the changes that need to be made. What would you advise there?
Well, I said this on a webinar yesterday too about project management, but you have to be really real about who you are as an agency and what your resources are. Okay, not everybody is Google, not everybody has these amazing tools at their disposal, and people have employees that are overtaxed and have other projects they're working on. I think so. The biggest thing you have to decide is who your internal resources are and what you're truly going to need external. You know, you're going to be putting in a new letter, so you probably need a map attorney. That's going to be an extra cost. You're going to be changing the letter as the example that we're using. And so then you're going to need your letter vendor. And you have to keep in mind too, that your letter vendor isn't the only one that works for you, right? So we all use the big names, the Rev Springs, the Microdynamics, all of them are also representing a bunch of other agencies, all trying to make the same changes at the same time. And you're going to basically get in line until they can get it programmed. So external resources are going to cost you extra money. Internal resources, you're going to have things like change fatigue, not enough people that can program the certain things that you need. Training is going to be huge across the board, and you need to make sure that when you put your timeline together, that you're doing it. Things need to be working at the same time. You can't just tackle one thing and then move on to the next, because you might need people working simultaneously. You need to leave time for testing, tweaking. And in my experience with agents, it takes, a good month or two for them to really get the hang of a new habit, and you need to make sure you're monitoring for that and doing some kind of soft rollout before you hit the ground running. So those are things I would keep in mind when you're trying to do a timeline and you're looking at your resources. But just really my biggest advice is to be real honest about who you are and what resources you have. And I mean, hell, call on your friends, right? It's a small industry. We're all trying to do the same thing. If someone asks you for information, I wouldn't be afraid to share it, and vice versa, because we're all in this together.
So a show of hands, who's lying to themselves about the resources they have available?
There's 144 participants. There's 144 hands who are up.
Right.
But Sarah, that's a great point. I think also, piggybacking on Catherine's point before about what's optional and what's not, it's a good time to sort of test some of those things. Of course, you don't, with some uncertainty remaining with the new administration on the rule, people may not want to use a model validation notice yet, but maybe there's some small tests that can be run on a limited content message compared to a Zortman message, which in my mind is still compliant. It's still vetted. We've used it for many years. We've had great success, very low in terms of actions reliability on the message, to the point where I was sort of surprised that we remember that, oh yeah, voicemails are a thing, that you have to be mindful of third-party disclosure. But maybe this new message, by taking out some of that debt collection, maybe you'll drive more callbacks that way. I mean, forget compliance for a second. I know that's really hard for all of us to do. Talk about driving revenue for 1 minute and think like, hey, talk about budget. Like maybe some of that budget should go into testing, analytics, and thinking about, wow, I really have two good options for a voice message, and maybe I can choose which one I want, and that can help me make a decision to drive more revenue. And then, of course, that takes time and effort and resource allocation and even some, upfront costs right now. But this might be the time to take some of those baby steps to monitor what might work for you under the rule where you have the choice.
Yeah. Like you're talking about with email before, I think the email, we have some guidance. It's going to be hard to implement, but if you're sending emails instead of sending letters, and you get to take all those letter costs out of your budget, that could be huge. Is that going to be worth the hours and hours of manpower used to set up the email properly? Maybe. It depends on your system. There are obviously a ton of really amazing, fancy programs out there that maybe one day your little agency can afford, but today you're going to have to spend a lot of hours training your staff on how to apply some of these rules. So that's every hour that they're off the floor doing training, that's an hour of their, they're not collecting. So all those balances have to be made in the next, how many, 6 months, 8 months?
That's kind of the fun risk assessment part about our jobs though, right? You kind of get to weigh whether it's worth the risk. And if you really get pretty granular, you can try an email campaign with a student loan, but not try it with a credit card, or, something with a medical different, and really try to play with that. Same with the voicemails and things like that.
Sarah, one last thought that I had on your point with the timeline and establishing your timeline to be compliant. I think lawyers, compliance officers, we're great on being subject matter experts. I don't know that we're the best project managers, but I think that role definitely needs to exist in your organization. Somebody needs to be able to implement and stay on track and use their Gantt charts and know what comes first and prioritize and really stay on top of it on a functional basis. So that's something that I think needs to be, you need to be cognizant of with your company, and that's one of the first check boxes you probably need to have is who's going to do this, not just the in-house counsel or compliance officer.
One of the things that needs to get done, Judd, is something you brought up, and that is sort of figuring out how workflows are going to work for opting out. Opting out is a big component of a lot of the different communication channels that are listed in the rule. And there's a lot that may have to go into collection agency systems and technology to make sure that you're capturing and sort of and holding on to any consent revocations that come in.
Right. Yeah. Well, what made me think of this is kind of the genesis behind why we have a new debt collection rule in the first place. It's updating the FDCPA from the 1970s, before we had all these electronic communications options, and bringing it into the modern age where we can, or on the regulator side, they're addressing communications with consumers via email, via text message, via social media platforms, you name it. And I think, with the good comes the work as far as being able to manage that successfully and compliant, in a compliant way. And that's knowing where the opt-outs are. So your agency, if you're going to engage in all those multi-channel or omni-channel, I don't like that word very much, communications methods, you need to be able to intake those, and they can come in a variety of sources. It's not just clicking the opt-out link in the communication that they receive. So if you've got a website that allows consumers to submit information or submit questions, if you've got an email address for consumers, if you've got a fax machine, snail mail, telephone calls, there are a lot of different ways that consumers communicate stuff to us. And being able to centralize that and triage it so that an opt-out or a preference request or anything like that falls under that request or demand from a consumer, you don't want to lose it. So it becomes complicated if you think about it initially. So that's why I suggest, really working out, whiteboarding it and visualizing what those workflows are so that you're capturing it in every way and you're centralizing the process so they're treated all the same. I think that's going to be important to do. One other part of that, don't forget your clients. So a lot of the information from consumers doesn't come directly to the collection agency. It will go to the client. So, a consumer gets a notice that they're in collections, they will go back to the creditor and say, what's going on? Or I don't want to talk to this person, or I will talk to you about my account, but not the debt collector, or I don't want to be called at work, things like that. Making sure that those communications come back to you so you can adjust the account, so you can make sure that you're adhering to those parameters and restrictions is going to be necessary as well. Centralize the workflows. Yeah.
I love the centralized database for the opt-outs. And one other thing to note is that just because today they opt out from the email doesn't mean a consumer might use that exact same email to communicate with you the next day and then opt out again and continue this back and forth. So your system has to be, flexible to account for, it's not just an on and off switch necessarily. You might want to keep record of all the back and forth, because I can see that as being maybe a spot where plaintiffs' attorneys might exploit that they opted out. They shouldn't have got another email, and you'll have that record of them doing it multiple times.
Yeah, I don't think any of us have ever been in a situation where we've been gamed by a consumer, have we? Yeah.
Not this morning.
Ari, consent, revocation of consent, that's something that, really requires, I think, and correct me if I'm wrong, like sort of really kind of requires close contact and working closely with clients and your creditors to make sure that sort of, that information is flowing both ways.
Yeah, I wrote down when I first read the rule, I just wrote down 2 words. It said consumer choice. And that's where they're focused. And that's kind of goes back to my point earlier, deviating from what the CFPB says or thinks is safe. Deep down, they believe and I think very well intentioned, that they think they're presenting ways to communicate with consumers that consumers want. And that they don't want you to say, well, technically, can we do this? When you say that word technically, that deviates from really their intent of what they're expecting. And I think the great thing is consumers want emails, they want texts, but they also the CFPB wants to make sure they have the ability to opt out. I don't think the CFPB will be sympathetic to someone saying, well, they told our client that we opted out, not us, to your point, Mike. I think that does have, and I think Catherine, that's exactly what she's saying, is the opt-out methods sort of have to be streamlined between you and the client, creating a flow of information of, hey, we got a call or we got an email from a consumer ourselves, and they said they don't want to be texted anymore. I mean, what impact does that have under law if they say that? We already know, dating back, the FCC's 2015 rule tried to make it very liberally for revocation under the TCPA. And I think one of the problems here is we've got a harmonization issue. I know that's one of our other topics, between TCPA and FDCPA now as the CFPB sees it, because they call into question text messaging and getting a downstream number from a client and your ability to message them under the FDCPA now. We know you might be clean under TCPA with a client provided number, but they're basically saying, we want you to handhold this consumer and talk to them first and make sure they want that text. Make sure that they opt in a proper way and have the mechanism to opt out. So what I think a big takeaway is with consumer choice, making sure your letters give them, let's just opt out, of course, that's mandated, but giving them the chance to opt into these methods of communication, like putting it on a letter, if there's short code texting, if the carriers ever allow us to expand text messaging, making sure to put that on a website, put that on a payment portal, put that on, other things. That's really key, I think, to driving our knowledge of how does a consumer want to be communicated? Is that going to be an online chat? Is that going to be an email? Is that going to be a text? Is that going to be a phone call? Meeting them at their level is what the CFPB really wants. And I think if you follow that bright line guidance and you instill that in your clients, so that everybody's got like a proper mechanism for it, you're going to be better off.
And that's probably something that you can start doing now, and you should. So that way you're capturing the right consents and emails and things that you need. So when you get to rolling out all these other mechanisms of communication, you've already done that and you have your database and you're okay. And that's probably something you can start on earlier before you start rolling everything else out.
With respect to consumer choice, we have a question that came in, and that is, how much risk do you see in keeping the patient choice in sync between agency and clients?
I think that goes to this unspoken and this evil word of regulation by enforcement that we came to know under a prior admin, the Cordray CFPB administration, which was basically saying we're going to pick apart different things that we think we don't like. It doesn't say it anywhere, but we think we don't like it because of what it means for consumers. I think we might be back to that. I understand that Chopra, coming from the FTC, there's a tendency, he said, to look at data, look at statistics, and he's willing to do that, which is fantastic. But I do think things that don't sit right with him and with the admin are going to end up on some lawsuits or some consent decrees. And we're like, whoa, where did it actually say we had to do that? So I think streamlining between creditors and agencies and who said what to whom and who revoked consent or opt out, I think streamlining that and getting the cooperation where there's giving a consumer multiple methods to opt out at the agency level, at the client level, treating that very liberally, getting client help in the opt-in process where it can be done under law will be huge, because I think it's inevitable that the CFPB wants that. And whether or not that's specifically articulated in the rule, I think it's something they're going to enforce upon and ask, because we know 8-9 years ago when this initial rule came out, big question was, our original creditors going to be regulated? I guess the answer is no, but it's really kind of, it's regulated through you, the agency.
Yeah, I think we can abandon the notion where a creditor could just place an account with an agency and have nothing to do with it anymore until they get their check, their recovery check. It's really a partnership, and it's been moving that way for some time. I think this is really ramping up the expectation that there are continual communications between the outside collection agency and the creditor, and that they are working in sync as far as the collections process goes on the consumer side, and not working against each other. And that's the only way to do that successfully is to maintain that conversation with your clients and have a point of contact, a client liaison, some role who will be able to facilitate that. And when you onboard new clients, those relationships are established up front and are strengthened over time.
And unfortunately, you're just going to have some hard conversations, and there might be some clients that you're going to have to let go of because they don't think it applies to them, or they can't get sophisticated enough to pass the data that you need, or you can keep them as a client but not do X, Y, and Z for them, some kind of communication. It's just going to be a wait on whether you can get everybody to buy in or not.
With respect to opting out, a question from the audience, and that is, do we have to give the consumers various ways to opt in or out, or can we give them one way to do so, thereby being able to track requests? Otherwise, it feels like it will be herding cats. Anyone have any insights on how to track or how to provide the opportunity to opt out or opt in?
Well, I think we know, if you look at TCPA guidance and you date back to the 2015 guidance, and I know that ACA thankfully won a case that worked back a lot of the evils of that 2015 guidance. But one thing that remained was revocation and the ability to revoke, and that if someone revokes in a reasonable way, you have to honor it. And then we get, the old law school examples. If I revoke AMC Theaters calling me, what if I tell the usher at the movie theater? Is that reasonable? Probably not. But what if I write a letter? Can I try to drive it towards email, towards a specific address? I think yes. I think part of this is going to be sorted out in the coming weeks and months as industry best practices get vetted out. The beauty of, I think, the email debt transfer letter sent 35 days before is the CFPB sort of says, hey, you guys are allowed to dictate the method of opting out of it. I think if it's not reasonable, or it's only one way, someone might say you've sort of inherently restricted someone without a computer from doing it. If they, now granted, you could say, how do you have an email if you don't have a computer? But you got to think through all these things. Like, are you missing some key mechanism or opt-out method that might be reasonable to a given person, I think.
And I believe it has to be clear and conspicuous, but if you have a very clear and conspicuous click here to opt out, but the consumer still just replies to your email and, just says unsubscribe, your system has to be able to, account for people who just sort of respond however they want to. If they put in the subject line, unsubscribe or remove me from this list, stop emailing me, you have to somehow have a system that can apply all of those different types of opt-outs, potentially.
So, Catherine, Ari, you're basically saying it depends, right? That's what lawyers love to say.
I like to throw this stat out there, but there's apparently more than 13,000 ways that a consumer can opt out of receiving text messages in a by using different words or combinations of words or emojis. So
emojis.
Is that accounting for all the curse words you
emojis
can use when you write back to a debt collector? Does that accommodate all the curse with the nasty things we get called?
Absolutely. Ari, you brought up the TCPA, and Sarah, that was something that you had on our list of 10 things, and that is sort of trying to figure out how Regulation F fits in with all of the other rules, regulations, and laws that that a company has to comply with.
Yeah, so in theory, we would just roll out these rules and we'd be done with it, wrap it up and we're good to go. But Unfortunately, we're governed by several more regulations and things you have to take into account. So if you're talking about, for example, email notices and things like that, you need to make sure you're, in compliance with all the financial regulations and the EFTA and things like that. When you're talking about calls, you need to make sure you're bounced across the TCPA and it's working. And the state laws is just a whole nother can of worms. We're looking at the model validation notice and that's cool, but I also need to make sure that I have the state disclosures for every single state and figure out how that plays into each other. So it gets pretty complex pretty quickly when you're just taking these rules and then looking at everything else that you do in your agency.
I mean, you just look at beyond even the law. You've got the CFPB presenting us with a study and telling us that people want text messages. This is a desire. This is what your consumers want. We're going to create a very complex, but apparently maintainable way for you to engage in this communication if you so want. And then, by the way, we're not going to sync it up with the TCPA and the 08 FCC downstream consent where you can auto dial, a number you get from your client that they've gotten directly from a patient or from a utility provider, whatever it might be. So you've got like a regulatory fail with the FCC and the CFPB here. But beyond that, we've got T-Mobile. 40% of all cell phones come under the T-Mobile umbrella right now. And they just released terms of service that said, we're not going to allow debt collection texts. Well, that's a really convenient time when the federal watchdog agency that we all know and love just endorsed text messaging and just said how much consumer choice is key. But we're just going to go block every message that mentions the words debt collection. And as you know, you've got to include that under the FDCPA. So I think they're starting to maybe rethink that. I know there's a lot of lobbying efforts going on, but that's a private business even that you're going to have to navigate through with these rules. And I think showing them all these steps and showing the steps that your clients do go through as well is key to getting permission opened back up for not just those 40%, but even the other 60% of carriers on the texting platform. So that's another mission we've got ahead of us of, hey, that's great. You solved the CFPB rule and you sent texts that now don't get delivered because the carrier rules are blocking them. So how do we become compliant with the carrier rules? Well, let's jump through these hoops now. So I think a constant focus on compliance with the FCC, the CFPB, of course, the FTC to some extent, what plaintiffs' lawyers are saying to some extent, and then private businesses like a carrier, all things you need to be mindful of. And I think just shows how key having a great compliance department is. We always remind our exec teams that compliance is so important. I think we're being very validated right now because we're going to be very needed in the next, 8 months and beyond.
I was gonna say next 50 years.
All right, so we've got only a few minutes left. There's a couple of things left on our list, and Cal, I want to circle back to something you listed, and that is getting the employees ready and everything that's going to come with sort of getting collectors ready to do what they need to do to comply with the rule once it goes into effect.
Yeah, specifically, I was referring to sort of the call frequencies and how there are great programs that can help track how many calls you've made on each account and the times, and maybe even have time, place, manner built in so that when you cannot reach out to consumer. But this is all going to take a lot of training from your staff, which means you have to have training materials updated, your manuals updated, reviewed by whatever compliance committees you might have. And I know these things do take time to not only put into work properly, meaning you've read the rules and you're putting it into your business practice, and then you're training them, and then you're signing off on that training, and then you're testing the training. This is actually something I think people could start doing now. For example, the call frequencies, start trying to, because there's a lot of rules around the right party contact and then having to wait specific amounts of time. So you really need to lock down, what does right party contact mean? How is that documented so that you can start tracking these and start the training now. That way, when the November deadline comes, your collector's already used to doing this. They're already looking for things, especially the guys who don't have the fancy, amazing programming available. They're doing it manually, maybe scrolling through their notes and counting the days. that's going to take training and a lot of practice. And I think that's something that can be started now. There is no prohibition to you calling 7 or less times per week. So maybe it's something you start training and doing.
Catherine, will you just do all my policies and procedure changes for me?
No.
Figured out.
Well, it depends.
No, for free.
Okay. But it's a big lift, everybody. I don't know about, I'm sure most of you don't have just 1 or 2 policies or 1 or 2 manuals hanging around. I imagine the last 10 years, it's grown to be quite a nice little notebook on your shelf, but it's time to pull them down, dust them off, and start looking at every single aspect.
Yeah, I mean, you know, the flip side, not the flip side, but the other ancillary issue to me on that, Catherine, is, you know, if we're talking about training collectors for the most part on changes in the laws and the rule and rulemaking and enforcement, you know, what motivates them? You know, you could say, well, if you don't do this, you're subject to disciplinary practices or progressive discipline or what have you. This is a requirement. We've now implemented this policy and procedure, and you have to adhere to it. But you know, everybody's experience is different, and you know, I've seen instances at my company, at other companies, where a collector, if they don't like a rule, then they find some way to subvert it and go around it. And you know, I've been kind of working on what's the internal messaging to collectors as part of the training, why they should adhere to these changes, why they should embrace them, and why it's good for them. And it, you know, ultimately that turns on what makes them have live conversations with consumers, what makes it easier for them to collect on accounts, and what makes it easier for them to resolve and close issues with consumers and move on and be successful at their job. And you know, a lot of it to me comes back around to, hey, this is giving us more guideline and more structure around new ways to communicate. And that's good because the old ways weren't working. RPCs were going down. People weren't opening their mail. And you know, what's left to actually get a consumer on the horn to be able to discuss their delinquency, their account with them.
Yeah, and part of the training is maybe you start asking, is this a good number? Would you prefer text or email? If you prefer email, can I have your email address? And we'll use that if you don't like phone calls. And you know, having those scripts and manuals put in place before you do it too, by the way. Write it down first. That'll help with defenses later.
Yeah, and I'm thinking, you know, this is akin to a few years ago when kind of the culture mentality in our industry kind of shifted from being an aggressive, pound the phone in the waste paper basket, you know, you better pay your bill or we're going to send the sheriffs after you. All those bad acts that gave the industry kind of a black eye, into more of a you know, high EQ listening and trying to work and have conversations and take that approach. And it's the fly and the honey analogy.
And that's the soft skills that Ari's saying the CFPB is going to be looking for when those actions potentially come out. That it's not a rule, but we just didn't like the way this call felt.
Yeah.
Right. Look, anytime you have to, I know we're short on time. Anytime you have to open your CMS back up, the compliance management system, it's sort of like you hold it under lock and key. You want everyone to read it in your business. You don't want to be sending it out too much, but there's a big focus. You know, if you've had to present it for an audit or had to do anything, you know, mission number one is you're like, I hope this was updated for X, Y, or Z. This is that opportunity to update it. And you may find things in there in your scripts or your processes that are completely outside of the rule, that you're like, you know what? I don't like our script for this. It's compliant, it's within the law, but it doesn't drive revenue, or it's not consumer friendly, or, you know, anytime you open that back up for revision, it's a good lesson that doing that makes you a better agency, makes you a better compliance team.
We're almost out of time. Judd, I didn't get to your last item, and that was sort of dealing with email, but you know, and Kat, I think we're going to skip your last item because I think we'll keep that just sort of between the panel. But Sarah, I think you had the best sort of 10th item on the list that everybody needs to do when it comes to getting ready for the rule, and I'll let you finish off our conversation today with that.
I think we were just saying, take a deep breath. It's going to be okay. We're all in this together. We've been through so many changes in the industry. And like we said, 50 years from now, we'll still be around. Just chunk it out and take a breath.
deep breath, everyone in, out,
Right.
you know.
Just keep swimming.
All right. Well, unfortunately, we are out of time. Kat, Sarah, Ari, Judd, thank you so much for your expertise and your wisdom today. On behalf of all of us watching and listening and learning, I appreciate you taking the time to share with us today.
Thank you.
Thanks to everybody. Thanks to TCN one last time for sponsoring today's webinar. Please go to www.tcn.com to learn more about the company. As well, I hope everyone takes a minute to share their thoughts in a survey that should load on your screen when I end this webinar. There's also a link in the chat box. I think you're even going to get an email tomorrow. So can't offer any excuses that you didn't see the opportunity to share your thoughts about today's webinar and offer any other ideas for future webinar topics or panelist suggestions. So hope you take the time and do that. Thanks to everybody for watching today. Have a great weekend. Stay safe. We're back next week with more webinars, more content. Hope to see you then. Take care.